Welcome back to this third segment of this law session dealing with, among other things, illegality, capacity, and certainly privity of contract. At the break, we were considering restraint of trade, and I said that immediately after the break we'd pick up with minors and also consider incapacity. What we will also do in this segment is we will make a start on privity of contract, and in the final segment, of course, we will close with privity. Now, if we start looking at contract with minors and also contracts which are impaired by virtue of some incapacity of one of the contracting parties, I want to start off by saying there are certain situations where the courts will refuse to enforce a contract because, for example, one of the parties is deemed to lack capacity to make the contract. Now, what we'll focus on here is this particular issue in relation to a person not having sufficient capacity. The fact is that there are persons under the age of 18 who are generally regarding as not having the capacity to make a binding contract. Now, the exceptions to the rule are certainly in place because the general rule is that if a person is under 18, you can't make a contract with that person. However, if it is that this is a contract for necessary goods or services or necessaries, or if it is a contract where it is a beneficial contract of service or other contracts related to earning a living or contracts which involve a long-term obligation, then the law may very well find that it may be enforceable. So the point is, of course, that just because somebody is under 18 does not mean that they can't enter into a contract. Now, what you will see, of course, is the types of minors that this particular area actually deals with, because it is generally people who are in some sort of celebrity status type scenario. So you have your singer who's singing from the age of 13 or 12, like Celine Dion, for example, or one of the cases we'll look at is the case to do with Wayne Rooney, who is a footballer, because it is quite legitimate, for example, for a 9-year-old who has particular skills to be spotted by a scout, and the next thing he's on his path to becoming a well-known, famous footballer. And so you start getting contracts being made on their behalf from a very young age. And so the question is, who are you going to bring the action against? So the point, of course, is that these are the types of contracts we're dealing with when we're dealing with minors. Now, the effects of entering into a contract with a minor, you have to consider both executory contracts and executed contracts. Now, executory contracts are unenforceable, so contracts which are to be performed. But executed contracts will stand. So if a contract you've performed, for example, and they're supposed to then give some consideration and they haven't, then executed contracts will stand in a court of law. Now, the adult party may be able to recover in such circumstances under the Minors Contracts Act 1987, even in relation to void contracts where age is the avoiding factor. Now, the obligation of a minor to make payment for necessary goods and services received will generally be one type of contract which will be upheld. The obligation is only to pay a reasonable price for goods, which of course falls under the Sale of Goods Act 1979. There's also, of course, liability against the minor in tort. Now, in general, the courts will not allow a tortious action to be used as a means of indirectly enforcing a contract, even where the minor has lied about his or her age. Separate and apart from age, mental disability and intoxication will also operate possibly to be a basis where a person is incapacitated so that a contract may be void. Now, similar rules will apply where a contracting party suffers from a mental disability or intoxication, provided the other party is aware of the incapacity. So if I'm making a contract with you and you are intoxicated and you're drinking something that clearly is masking me knowing that you're intoxicated and you're acting pretty much in a normal manner, then my being unaware of it may mean that I may be able to claim against you. But if I know, for example, that you're intoxicated and seeking to take advantage of you, that is where the law seems to draw the line. The general rule, of course, is it is always freedom of contract. And in order to make a valid contract, an enforceable contract, both parties must be regarded as having capacity in law to enter into the agreement. So there must be consensus ad idem. So the reason for intervention by the courts on the basis of a lack of capacity may arguably rest on the need to protect the contracting party from himself or herself. Now, those who have not reached the age of 18 are regarded in England and Wales as minors and as such have very limited capacity to enter contracts. Now, the choice of age for this purpose is inevitably arbitrary, but it does follow the general law. It's 18 for most things. The law, of course, is using 18. And so you get this kind of paternalistic feel that minors are being protected from the consequences of their own actions. Now, the question is, should they be concerned with whether there is a genuine consent to the agreement on the part of the minor, and does he understand its consequences? Because you may be protecting somebody who is 17 but who is pretty much business savvy, being in the industry maybe since they were 11 years old or 10 years old, as the case may be. That said, it just seems to be a situation where the courts will take from that standpoint. The law starts from the presumption that all minor contracts are either void or voidable. Now, there are two main exceptions as we flagged up: the contracts for necessaries and beneficial contracts of service. Now, as we look at the cases, you will see that the cases, insofar as necessaries are concerned, the courts will stand strictly to them. Now, the reasoning is that if you did not allow for the necessaries, it may very well be that a minor is disadvantaged. The concept of necessaries covers goods and services was explained in some detail in the case of Chaplain Cooper, where it was held that a widow who was a minor was liable in contract for the cost of her husband's funeral. Now, according to the judge in the case, necessaries include not only things which are absolutely necessary for survival, but also those which are required for a reasonable existence. Food and clothing are obviously covered, so are medical assistance and education. Once the goods or services are of a kind which can be put in the necessaries category, then there is a further question as to whether they are appropriate to the minor in the situation. Now, can you call, a fancy dress, a very nice dress, a necessary? Well, it may depend, because if you are Rihanna, it may very well be a necessary rather than anything else. But if it is that you are just a regular person like you or I, it may not necessarily be a necessary. Case in point is Nash and Inman in 1908. In that case, we have the plaintiff, who is a tailor. The defendant, who is an undergraduate at Cambridge University, had ordered 11 fancy waistcoats from him. When the plaintiff sued for payment, the defendant pleaded lack of capacity. The plaintiff argued that the waistcoats were in the category of necessaries. The court said that there was no doubt that they were among the class of thing, that is clothing, capable of being necessary. necessaries. It was up to the plaintiff to prove, however, that the defendant was not already adequately supplied with items of this kind, which he was unable to do. So again, looking at the kind of defendant there, the court said, well, for him, it may very well be a necessary, but can the plaintiff prove that it was? Now, the plaintiff was unable to enforce the contract. It should be noted that this case made it clear that the trader who is ignorant of the minor's situation will not be protected. The decision is made by looking at matters entirely from the minor's point of view. Now, we have, of course, certain types of beneficial contracts where it is in the context of, for example, a work relationship, and we have got cases, for example, like I flagged up before, the Wayne Rooney case. Now, that is an important case because it allows you to see how a case, for example, may be viewed from the court's point of view. Now, the case in point is Proform Sports Management and Proactive Sports Management Limited, a 2000 case, and as I said, it involved the footballer Wayne Rooney. Now, in 2000, Wayne Rooney was 15 years old. He entered into a representation agreement with an agent who was the claimant in this regard. Now, in 2002, Rooney terminated the agreement and entered into an agreement with another agent, the defendant. Now, the claimant sued the defendant for the tort of interference with contractual relations. Now, in order to decide whether the tort had been committed, it was necessary to determine whether the 2000 agreement was enforceable. The court said that the 2000 agreement was not a contract for necessary services. It simply provided for representation services and did not involve finding Rooney work. Rooney was already registered with Everton Football Club at the time, which subsequently employed him. The 2000 agreement was therefore voidable, and there was no liability in tort for inducing or facilitating the breach of a voidable contract. Now, the effect of entering into a contract with a minor, well, you can property transferred, can it be recovered, for example? If the contract is for necessaries, is the minor obliged to pay the full contract price? Well, the answer to these questions will be discussed as they relate to a void or a voidable and enforceable contract. As it relates to void contracts, the first point to note is that since the passage of the Minors Contracts Act 1987, it is possible for a void contract to be ratified on the minor attaining majority. Now, it would then, of course, be the contract will take effect as normal with full enforceability on both sides. As it relates to enforceable contracts where a minor has received necessary goods and services, what is this obligation as it regards payment? Well, as far as goods are concerned, the position is governed by Section 3.2 of the Sale of Goods Act 1975, which says that where necessaries are sold and delivered to a minor, he must pay a reasonable price for them. There are 2 points which emerge. First, the liability only arises after the delivery. The fact that ownership passes under the Sale of Goods Act for the purposes of passing of property is irrelevant. So I know that this is contract law, and if you do commercial law, you will get into the passing of property and risk. But the law talks about, property passes, Section 16, Section 17 of the Sale of Goods Act. But for our purposes, those issues are irrelevant. The point here is that there must be delivery. Second, the liability is only to pay a reasonable price. Now, the cases as we've looked at, as I say, I would suggest you consider them in relation to this. We will, of course, start on the doctrine of privity. Now, we're just going to do a brief introduction, and when we come back, we will ventilate it further. But I do want to flag up before we break just exactly what we're looking at. Now, privity of contract considers a situation where only the parties to a contract may sue on it. So the law says that when you consider a party as between A and B, C cannot sue A or B based on that contract, even if A and B have agreed that the contract is for C's benefit. That is the idea behind privity. Only the parties who are the contracting parties may sue on that. There are 3 cases in relation to privity. You must know them. It's Dunlop and Selfridge. You've got Tweddle and Atkinson and Besig. These are standard bread and butter type cases. You need to know them. You need to know what they provide for, because any discussion will obviously require some analysis of these cases. Now I'm going to look at each of them in turn. I'm going to start off with the Dunlop case. I'm going to look at Tweddle and Atkinson. I'm going to look at Besig, and then we're going to break and then complete with a full discussion on privity. Let's start with Dunlop. In Dunlop, the plaintiff, who was Dunlop, sought to establish and enforce a resale price maintenance scheme. Now, the plaintiff sold tires to Dew & Co., who are a tire dealer, who then sold to Selfridge on the condition that Selfridge would not sell below the list price. Selfridge failed to comply with the condition, and the plaintiff sued for breach of contract. The courts held that although the promise made by Selfridge to Dew not to sell below the list price had been made for the benefit of Dunlop under its retail price maintenance scheme, Dunlop was not entitled to enforce the contract against Selfridge because it was not a party to the Selfridge and Dew contract. Now, what about Tweddle and Atkinson? Well, John Tweddle, the plaintiff's father, agreed with William Guy, the plaintiff's father-in-law, for Guy to pay money to the plaintiff upon the marriage of their respective children. Now, Guy died before making payment, and the plaintiff, William Tweddle, sued the estate. Atkinson was the executor. He sued for the promised sum. Now, the court said that no consideration moved from the plaintiff to Guy, and therefore the plaintiff had no right to sue on the contract. The court said that natural love and affection is not good consideration. That's what Justice Crompton said anyway. The point, of course, is that when we ventilate in the next session, in the next segment, the area of privity, we will see that all in all, Besig as well as this particular case are 2 that we will have to consider in light of the recent act. Now, finally, Besig. Besig was a coal merchant, and he agreed to sell his business to his nephew. The nephew in the case was the respondent, and it was that if he paid a certain sum for as long as he lived, and then to pay old Besig, I'll call him that, old Besig and young Besig, the young Besig was to pay old Besig's wife, who was the appellant, each week the amount of £5 for the rest of her life after he died. Well, old Besig died, and young Besig only paid the aunt once. Mrs. Besig, of course, filed an action against him, and the long and short of it is he paid 1 payment. Now, the thing was that the aunt failed in her own capacity at first instance. She won at the Court of Appeal. Lord Denning was sitting in that. But she lost in the House of Lords, and the court in the House of Lords said no, she could recover in her own right. But the court were in fact fair and actually allowed her to recover on the basis of being an administratrix of the estate. We're going to pause now, and when we return, we will wrap up this session of Privity of Contract, and so after the break we'll continue.